Welcome back. It's the 4th of July weekend, and we're celebrating here on the IRS Radio Hour with the gang, Deborah Schreiner and Jim Leahy.
That's right, ladies and gentlemen. We hope you are having a wonderful 4th of July weekend. But remember, the show is sponsored by Open Tax Resolution. I didn't get to say this. 312-664-6649 or visit chicagotaxteam.com. That's going to be your hub to help fight the IRS.
What do I do on the 3rd of July, Jim?
You put out the hot dog stand. We have a wonderful, rousing party. We're talking about liberty, talking about happiness, and talking about the pursuit of hot dogs.
And I eat a lot of hot dogs and drink old-style beer.
Yes.
Falstaff. I think I'm Harry Carey. See, Harry Carey always did Falstaff beer. When he was with the Sox. When he was with the Cubs, he was a Budweiser guy. But anyway.
I have learned to drink all types.
I haven't learned.
I am
not
very
to drink.
diverse in my libations.
And I am not. I go someplace if they don't have old style. I have some seconds. I'll drink PBR. I'll drink Rolling Rock.
Oh,
I'll drink. But I'll drink Heineken because everywhere you go they have Heineken. If you go to some party, they'll always have.
You used to drink Special Export.
I'll drink Special X. That's old style.
Nobody really drinks that. That's not out there anymore.
I have a story about that, but we're
not going to put that on the radio.
No, it's radio, but I'm not going to. It's
radio friendly.
It is radio friendly.
Video killed the radio star. Did you know that?
So let's do this intro here.
It's the blog segment. The blog. The blog.
Okay,
let's go on your blog segment.
I was doing something. I was reading something that just captured me.
Remember, statehood before self, selflessness. How do we? Debbie, how did you say it?
Statehood before self.
That's right.
Statehood before self. That is our new. What do we say?
We got to stop this
motto.
And this is the whole thing. Now they keep blaming Rauner like he's the guy.
Let's go on to the blog. Okay. I don't mean to get you all riled up. Let's go on to the blog and talk about Neil Gorsuch.
That's what we want to do. So let's talk about the judge.
Now everybody know I am the judge.
And I'm going to tell you something. When Trump was running and people said, he's a liar, he's a thief, and he put out the 21 names of potential judges that he would, and I was very impressed with those names. Each and every one of them, I said, would be 10 times better than anybody Hillary would pick or anybody else on the left. Okay, not only Hillary, anybody and many Republicans, because a lot of these Republicans have put these losers in too.
Understood.
Okay, we need somebody that's focused on liberty and freedom and the textual
that just reads the law.
Read the law as written.
The law is
unbelievable.
How many times do we say it on the show that it isn't? It's not like there's not different shades of gray to this. It's black and white. This is what it says.
I agree. And in my opinion, if the Gorsuch is the only thing that Trump does, the only thing, it's worth all of these tweets and all of this uproar. He is worth it because he is going to save us from ourselves. And these judges who write their own laws as they're and this is exactly what we needed is a guy like Gorsuch. And he is my new. This is what happened with the Cubs that I had to.
Listen, okay, come on, you're all over the map.
No, because I have a new favorite guy. The new favorite guy is Gorsuch, and I love Justice Thomas. Scalia was my all-time favorite. Loved him.
He's got Topps trading cards at home with all of them.
I do.
What about Trey Gowdy?
I love Trey Gowdy, but he's not a Supreme Court justice.
Okay.
But I would like him on there. I would. But could he be better than Gorsuch? The answer is no. Okay, because he doesn't have the experience. One thing Gorsuch does well is write opinions and put his ideas very clearly.
Have something
and that's what I just want to do. One thing, I'm going to read the first paragraph. Okay, now this just to give you some context. Whenever a new justice comes in, the old justices like to have him write his first opinion to be unanimous. So they're not writing against him and calling them names and stuff. That'll come. That'll come. So I think that in this opinion that he wrote, that the lefties would have been against it, but they gave him this clean shot. And this case. It's called the Santander case. Santander is a credit company who finances bad credit people to buy a car. Okay, and they go to collect on the debt. There's this Fair Debt Collection Practices Act that applies to and this is why it's so good deep in my heart, because I work with the Fair Debt Collection Practices Act and collectors, because this limits collectors, and so this position. But I'm going to read it. I'm just going to read the first paragraph.
Let's hear it.
Disruptive dinner time calls, downright deceit, and more besides drew Congress's eye to the debt collection industry. From that scrutiny emerged the Fair Debt Collection Practices Act, a statute that authorizes private lawsuits and weighty fines designed to deter wayward collection practices. So perhaps it comes as little surprise that we now face a question about who exactly qualifies as a debt collector, subject to the Act's rigors. Everyone agrees that the term embraces the repo man, somebody hired by a creditor to collect an outstanding debt. But what if you purchase a debt and then try to collect it for yourself? Does that make you a debt collector too? That's the nub of the dispute now before us. Now, I just read that. That puts it all in. It's so clear exactly what this opinion is. And as an attorney, I have read so many opinions. You could read the whole darn thing and not really know what the heck they're talking about. But he puts it in this so clearly exactly what the issue is. Okay, so it's very good. And I'm not going to read the last paragraph, because the last paragraph is, again, encapsulates exactly his understanding and mine, to be quite honest with you. So now I'm just trying to go to the bottom of this opinion. Like all of them there, but the whole opinion reads like this. The whole opinion is very clear and concise.
You're fired up.
Yeah,
I love it.
Because the guy is awesome. Okay, so
in
the end, reasonable people can disagree with how Congress balanced the various social costs and benefits in this area. We have no difficulty imagining, for example, a statute that applies the Act's demands to anyone collecting any debts, anyone collecting debts originated by another, or to some other classes of persons still. Neither do we doubt that the evolution of the debt collection business might invite reasonable disagreements on whether Congress should re-enter the field and alter the judgments it made in the past. After all, it's hardly unknown for new business models to emerge in response to regulation, and for regulation to address the new business models. Constant competition between constable and query, regulator and regulated, can come as no surprise in our changing world. But neither should the proper role of the judiciary in the process to apply, not amend, the work of the people's representative. So that is such a encapsulate exactly what I think a judge should do. Read the statute, apply the statute as written. If you want, and this whole argument was, well, this was a new area, and I think Congress, if they would have known it, they would have applied it to them, but they didn't, because this didn't really exist. And so he's saying, well, if you wanted to, it can encompass them, but go back to Congress and tell Congress to change the law. Okay. I'm not going to change the law for you.
Okay, so after reading that, what was the decision on the Santander?
He read the opinion and said Santander, it doesn't apply.
To the people that are just
it doesn't apply to them. They're not debt collectors. They're collecting for their own debt, and that's it. So the statute doesn't apply to them. And I wish I had more time, because there's another one, but this was a dissent, and a dissent on the Second Amendment in California, that the court decided not to hear a Second Amendment case from California, and Gorsuch and Thomas wrote a great dissent. And maybe we'll talk about that next week. Maybe that's what we can do.
That'd be a good one.
About the Second Amendment and how it and he wanted to hear the case so he can make these. Now, the next term, there's some important religious cases, right, about the Baker case. The baker who baked the cake for the gay couple, and he wouldn't bake the cake for their wedding.
He wouldn't make them the cake
for their wedding, okay? Or the florist and all these cases are coming in next term, and we're going to hear what they have to say about that. I'm going to predict that I think that they're going to find that these bakers and the florist has a right not to do something. You can't make them do something that they don't want to do.
Well, anyway,
and that's my prediction.
I necessarily agree with that too, because you can't
force somebody to do something.
Right. Anyway, well, ladies and gentlemen, remember, Open Tax Resolution is there for you. 312-664-6649, or visit ChicagoTaxTeam.com. That's going to be your hub to help fight the IRS. You can access old videos. If you don't get your question answered on this show, you can go and read blog reports and, again, watch previous videos and get a way to contact Attorney Stephen Leahy. It's a great tool to help you get back on financial success. So, ladies and gentlemen, stay tuned because after the commercial break, more IRS radio coming at you here on AM 560, The Answer.